Welcome to Underrated
In
Democracy.
particular, my friend, Mr. Maloney, I don't share his analysis of the importance of this study. This is not a political opportunity to gain points. This is an opportunity to improve access to justice. Every Canadian has an absolute right to receive timely justice, whether that be in the criminal realm or the civil realm. And we're all lawyers, and I can just anecdotally share with you that this issue of the lack of urgency in judicial appointments is a chronic, serious issue that is undermining the functioning of our judicial system. So much so that the Chief Justice of the Supreme Court of Canada had to cry out and make public his real deep concerns at the pace that the federal government is appointing justices. Where I will agree with Mr. Maloney is that after the appointment of our new Justice Minister and the Attorney General, there has been a sense of urgency in his office. He has appointed far more in the time that he has held that office than in the 4 years previously occupied by David Lametti. David Lametti, in a CBC News report, said essentially, not my problem. I wanted to appoint. I was hamstrung by the PMO's office. Now, the process is very clear. Under the current judicial appointment process, the Justice Minister is responsible for recommending a candidate for approval. There are 3 aspects to that analysis: highly recommend, or do not recommend. Justice Minister recommends a particular candidate for approval following a due diligence process overseen in part by the Prime Minister's office. So he was accurate to say that it wasn't strictly his decision and his lack of a sense of urgency. He was stymied, essentially, by the lack of urgency in the Prime Minister's office. And that should send a very serious, alarming signal to all Canadians and to all members of the judicial process. Now, Mr. Maloney says, well, in the last week alone, we've appointed X amount of justices, and today, 8 justices. That's great. I haven't seen the news. I haven't seen the reports. I'm not going to doubt the authenticity of what my friend had to say. But I can tell you that 6 months ago, when Justice Wagner cried out for assistance and had a personal one-on-one telephone call with the Prime Minister, there were 79 vacancies. As of January the 1st, and anyone can do a Google search through the Office of the Commissioner for Federal Judicial Affairs Canada, across this country, as of January the 1st of 2024, there were 78 vacancies. So, but for the comments of Mr. Maloney, we've improved on the stats by 1 justice. Because inevitably, the justices that often are considered for federal judicial appointments tend to be senior members of the bar. There are mandatory requirements for retirement. There is options for federal justices to change their status from fully engaged or fully active justices on the bench to supernumerary status, which means they only sit a very limited amount of time per year. But every year, cyclically, we have a number of justices moving into new categories or flat out retiring. The numbers are always increasing. So the fact that we've got 8 new appointments today, that's great. Come February the 1st, we could be 12 down. So the problem does not go away. This problem of not completing a full complement of federal court justices has existed for decades. Ever since I've been a lawyer, there has never been enough justices. And when you don't have enough justices, your access to justice is denied. So much so that the Senate, 2016, produced a study called Delaying Justice is Denying Justice from August 2016. And one of the recommendations is to appoint more judges on a timely matter. Here we are, 8 years later, still arguing that the appointment process is not efficient, that it often takes 8 months to a year, if not longer, to appoint justices on the bench, and the impacts are profound. Now, I've quoted you what Justice Wagner, or actually I haven't quoted what Justice Wagner had to say. I might take this opportunity to do that right now, because I think his words are very telling. Judicial vacancies are having, as Canada's Chief Justice sounded the alarm over the serious consequences of judicial vacancies, he said in a wrap-up, he's highly critical of the current pace of judicial appointments, warning that languishing vacancies on courts across Canada are exacerbating an already alarming situation. The empty positions have a significant impact on the administration of justice, the functioning of our courts, and access to justice for the public. It has major effects in every province of the country. According to Justice Wagner, there are suitable candidates available in every province and territory, so there's no reason why these vacancies cannot be filled. As noted by Justice Wagner, subcourts have been operating for years with vacancy rates of 10 to 15%. He said it's not unusual to see some positions remain vacant for months or in some cases years. This, even though in most cases, this is quite telling, Madam Chair, when judges retire, they give 6 months' notice to their respective Chief Justice of their province. This isn't an abrupt decision, I'm going to retire next week. There is a process, 6 months process for vacancies to be filled, but it's not happening. I pulled another article from a civil litigator in Toronto by the name of Catherine Marshall, and she wrote an op-ed in one of our papers not too long ago, and the title is, "Our Judicial System is Broken, but Politicians Don't Seem to Care." Well, I can tell you, this politician certainly cares. The entire Conservative bench certainly cares, which is why we brought this motion. She indicated there was a particular victim from an Ontario town who was scheduled to testify against her alleged rapist past summer. But when she turned up for her day in court, she was told her case couldn't proceed because there was no courtroom available. She says, talk to any lawyer and they will tell you the horror stories about turning up for day one of a trial only to be told there is no courtroom or judge available. For lawyers, it is frustrating, but for a victim of crime who has mustered the courage to come forward, it is beyond devastating. Now, we all know how our criminal justice system has changed in light of the Supreme Court of Canada decision in R.V. Jordan. Jordan has set a presumptive ceiling by which cases must be completed in the lower courts and in the Superior Court. 18 months in the lower court, 30 months in the higher court. When you don't have judges to fill the courtrooms, you have serious cases, sometimes homicides, serious domestic violence, serious gun offenses, where the judge is ultimately hearing a violation of the right to be tried within a reasonable time, will often conclude that the Crown has not discharged its onus, that there is a charter violation, and that violation results in a withdrawal or dismissal of the charges. Now, what kind of message is this committee sending to victims across this country that you don't matter? We already have a serious issue with domestic victims coming forward because they don't trust our system. We have an opportunity as parliamentarians, particularly in this committee, which should be charged with the responsibility to ensure the timely, efficient delivery of judicial services, both in the criminal and civil field. To turn down this very serious, important, relevant study, in my view, is shameful. Thank you. Those are my comments.
Thank you, Mr. Brock.